Good afternoon and welcome to Covered and the Law. This is your legal light and help law in these trying times. I'm Samson Ladi Anyanini. This afternoon we treat the question of unfair labor practices. What are they? What is it that your employer may do that will constitute unfair labor practice? And what is it that you may do against your employer that may be deemed as unfair labor practice? But there are three of you that have sent us specific issues, concerns about your circumstance at your workplace. We'll take those three and hope that in resolving all the three issues you have sent to us, we would have resolved many issues by many of you. This is Covered and the Law. We'll be right back. You're welcome back. This is Covered and the Law. This is your legal light and help law in these trying times. And this afternoon, we are looking, as I intimated, at unfair labor practices. That is a big subject on its own, but we'll quickly go through a list of the things that constitute unfair labor practice in the workplace, just so you are empowered to know what these are. And after that brief introduction, taking you through what constitutes unfair labor practices, we will settle to resolve three major issues that you have sent to us. And we hope that by resolving these issues, there are many other people who have similar situations who will also get the relief that the resolution brings. Once again, we are very grateful and privileged to receive in the studio Charles Bawaduah, who is a private legal practitioner and former executive secretary of the National Labour Commission. After his first appearance here about 3 weeks ago, you have called on us many times to have him return to the studio. Today, he has made time. Thank you very much for making time to join us, Charles.
You're most welcome, Samson.
Great. So, straight to the point, start with, we are all in our various places of employment and a lot of things go on in the workplace. What are the things that will constitute unfair labor practice and what can we do about them?
Thank you very much, Samson. Let me say that unfair labor practice as a subject is primarily intended to protect the relationship between a trade union and an employer or an employer organization. Just like trade unions can come together to form a federation, employers too can also come together to form an employers organization. So when we say an employers organization, that's what we mean. So unfair labor practices are provisions made in the Act that are intended to protect this relationship so that one does not interfere into the activities of the other, or the activities of the other should not undermine the work of the other organization. So that the activities of a trade union should not undermine the work and activities of the employer, just like the employer should not interfere into the activities of a trade union.
Right.
So in the Act, you would see in section 127, a list that has been provided that constitute unfair labor practices. If you read through, you will see that there are more of trade union related activities.
Right.
So you will say that unfair labor practice is distinct from unfair termination.
Right.
Some people often have the tendency to mix the two, but this is sometimes an unfair termination can constitute an unfair labor practice. So you will see in section 127 a list of activities that will constitute unfair labor practice. The first among them is it provides that a person who discriminates against any person with respect to the employment or condition of employment because that person is a member or an officer of a trade union is guilty of an unfair labor practice. So that if the employer, discrimination
Okay.
on the basis or principally because you are a member of a trade union, at the workplace, Mr. B belongs to a particular trade union. Mr. B does not, the other Mr. C does not belong to that. Because Mr. B belongs to a particular trade union and you don't want him to be in that trade union, you engage in activities such as reducing his salary, his leave days, such activities as to discriminate, treat him differently.
Right.
Most of the time adversely. Because he belongs to a trade union. The idea is to ensure that he leaves that trade union. You are engaged as an employer in an unfair labor practices.
Okay.
So that is the first one.
We know there are trade unions that are very vibrant,
Yes.
that take the employers on.
Exactly.
And so the employer may not be comfortable that you belong to that trade union, and therefore may give better treatment to your colleagues and then treat you badly because you belong to that trade union.
Yes.
So you say the first item, as regards the law, section 127, which constitutes unfair labor practice, is discrimination.
It's discrimination.
But discrimination on the basis that
You belong to a particular trade union.
trade union. Okay.
So the idea is to discourage you or dissuade you or to ensure that you leave that trade union.
Right. Okay. Let's get to
So
the
that
next.
is an unfair
Let's
labor
get to
practice.
the next. And please pay attention, because we have discovered in the course of hosting Covered and the Law and listening to your issues that most of you don't even have any union in your workplace. And the employers don't also seem to encourage unionization. So there are no unions to represent you and to help you, as it were, voice your concerns and to have them addressed. So often you are alone. And when you are alone, it's more difficult. But if you're a union in your place, you have an organization that you belong to, that will represent you, it is best, because the organization can also save you from suffering personal attacks, because it's an entity representing all of you, rather than you alone as an individual approaching management and asking for certain things to be done. Right. So discrimination, and then number 2. So you take us through, let's say, about 5 of them.
Yes.
So number 2.
The second one is also closely related to the first one.
Right.
Which is about threats.
Okay.
If you threaten to dismiss a worker or to impose any penalty or sanction against a particular worker because he belongs to a particular trade union, you are engaged in an unfair labor practice.
All right.
If you terminate the employment of a worker because he's a union leader or he belongs to union A instead of union B, that is an unfair labor practice.
So there are people who have actually suffered terminations because they are vocal, they belong to a union,
Yes.
and they are representing the interest of the collective. And the way they go about their things, employers are not happy.
Are not happy with them.
If you deal with them in that way,
Yes.
you have committed an unfair
Exactly.
labor practice.
Intimidating the worker because of that. Or you increase wages
Okay.
to workers who are not members of the union and leave those workers who are members of the union. The idea is, workers will normally want the maximum remuneration possible. And so if you do that, and the idea is to ensure that people leave the union, to be non-unionized, so that
Yes.
the employer can manipulate. When you do that by increasing salaries and leaving those of union members, you are engaged in an unfair labor practices.
Right.
And the law does not allow that.
Right. Okay. And in dealing with the union that way, the law also is against interference by the employer
Yes.
in the union activities or
Activities,
affairs
yes.
of the union.
Of the union.
Right.
So that the employer should not be involved in trade union elections. I know situations where management actually get deeply involved as to who should be union secretary, who should be union chairman, and all that.
Right.
All that is an unfair labor practice.
Right.
You're supposed to leave the union as an independent entity, no interference.
Great.
Let the members who have voluntarily and willfully joined the union by their own volition be allowed to choose their leaders.
Okay.
You should not engage in that at all. For if you make contribution, an employer makes contribution to the trade union without with the intention to influence the activities of the the employer is involved in unfair labor practice, and the law will not permit that to happen.
What next?
Then also you have the situation where the employer seeks by any kind of threat or intimidation during negotiation or collective agreement, they are also guilty of unfair labor practice. You know, annually, the union and the employer are supposed to sit down and negotiate aspects of the collective agreement which keep changing. For example, salary and related activities. Okay. When these negotiations are going on, either side is not supposed to intimidate. Okay. Say, for example, the workers wearing red bands, you know, threatening we will go on strike. If they don't increase our salary by 20%, by 25%, we will go on strike. All that unfair labor practices. Or the employer saying that if you don't agree to this term, we will reduce our staff and we will sack some of you. Right. All this.
And one of the issues we are going to be dealing with very shortly, you find that this might be one of the things that is rearing its head as far as the group that is seeking their welfare is concerned.
Yes.
Coming to the negotiating table and agreeing on what has to be done. Maybe let's take one last issue.
Now,
what constitutes unfair labor practice?
Exactly. In this regard, it relates to the union activities.
Right.
You should not, as a union leader or a union member, during the course of work, engage in trying to lobby people to join the union. Right. You know, trying to convince people. That is, say, doing trade union activity whilst at work. Right. It is not permissible. It has a tendency to interfere into your productivity level, and the law does not permit it. Okay. When you do that, you are engaged in an unfair labor practice.
Right. So I was asking the last issue, but you explained something to represent the last issue. So lastly, because the purpose of this discussion is because of what we have realized, that most of the places, they don't have a union, no organization, they are all scattered, and people must go individually to seek their welfare. And in the COVID time, you find that many of them are becoming helpless because they have to deal with the employer one by one, instead of having a union that will deal with their needs as a collective. It's a better option, particularly in the COVID time, than you dealing on any individual basis. If you can now spend just a minute to tell us how the employer is supposed to facilitate the trade union activities in their own benefit, which if they don't, maybe unlawful.
You see, there's a difference between facilitation and interference. Right. Let's get that clear. Because earlier we have made a point that the employer should not involve in trade union activities as well. But when we talk of facilitating, the employer is enjoined to provide certain facilities, for example, a meeting place for the union. The union requires a place to meet. The union requires time to engage its members. The union requires certain facilities from the employer to be able to function. Maybe a trade union office within the workplace. The employer is enjoined to provide these things to make sure that the union is not just in existence by name, but that function actively as a trade union has to be able to fight and protect the rights and interests of its members. So these things the employer is enjoined to do. And when the employer does not do this, he may be engaged in an unfair labor practice.
Okay. So, as we have already intimated, this is for the purpose that you may have a collective, and the purpose of this is so that wherever you are as workers, particularly in COVID, in these times, you are better off coming together and being unionized. And your employer must understand that this is good for all of you. And then you would, from time to time, as the issues are coming up, your unions will lead the process and not you as an individual, where it is very easy to victimize you and to have things done against you that you may lose your job or may not be happy about. Now, we are going to the 3 issues that you sent us. And in answering them or resolving them, you find that some of these issues actually come up. Now, let's begin with one which has to do with the hospitality industry that has done something. Now, a hospitality company sends about 90% of its workers home due to COVID for a skeletal staff to work. It agrees to pay them 50% of their salaries, but has failed and is rather employing temporary staff to fill the positions of the permanent staff sent home. Managers, some of whom are still taking 100% salary, insist there is no money to pay the 50% promised. What can these workers do if managers refuse to negotiate with the union? So this is one big issue that we have for today.
Thank you, Samson. But before we get there, let me make an important point regarding unfair labor practice.
Okay.
Now, so when the workers are engaged in unfair labor practice, or the employer is engaged in unfair labor practice, the affected party is permitted to make a complaint to the National Labour Commission.
Correct.
For redress. And the commission, upon hearing the matter, having resolved that there has been an unfair labor practice, can do a number of things. One, the commission can order or make an order in the nature of a restraining injunction to prevent the site engaged in unfair labor practice from doing so.
All right.
Or order compensation for the affected party, or reinstatement in the event of an employee being terminated as a result of it.
Okay.
Now, more crucially, it is important to note that the orders made by the Commission on matters relating to unfair labor practice are treated as orders of a high court.
All right.
Very key. That is because other decisions of the Commission are not necessarily decisions of the High Court. But when it comes to unfair labor practices, a decision made by the Commission has the effect of a decision of the High Court.
So if you violate it,
yes, you are in contempt.
Risk of getting to be fair.
Exactly.
Okay.
You will be in contempt. If you are if you disagree with such a decision, the law says that you can appeal to the Court of Appeal within 14 days. If you fail to appeal within 14 days, then you are locked.
Yes.
So that's important.
It means you are bound.
Exactly.
Okay.
And for practitioners and all of that.
So that's education that has to go down to all of you. Again, all of us. If you have set up the union and things are going on and the management and your employer, you're having issues that are not getting resolved, and you can identify the unfair labor practices we have mentioned here, go to the Labour Commission and make a complaint. They will intervene. They can ask your employer to stop, or if it is the employees who are at fault, they can ask them to stop, or if they have to make some compensation, they can do so. If some people have been sent home, they can instruct that they be brought back. And the decision they take has the status of a high court decision. If you violate it and you don't, if you don't appeal within 14 days, you have lost the right, you must obey it. If you violate it, you will suffer punishment for contempt of court. Now let's get to our issue that we raised. The company has sent home 90% of the workers due to the COVID and is keeping a skeletal staff to work. It has agreed to pay them 50% of their salaries, but it has failed to do that. And in the meantime, it is employing temporary staff to fill the positions of these permanent staff that is sent home. It said it was going to pay them 50%. It hasn't done that, but managers are still taking 100% of their salaries. When they ask the employer what is going on, they are simply saying, the 50% we promise you, we don't have the money, so we can't pay. Yet they are refusing to negotiate with the union. In this case, they have a union.
Thank you. That's a very interesting scenario. You see, the decision to send 90% of the staff home is a management decision.
Right.
A decision made by the employer. The employer has a right under Section 8 of the Act to decide whether to reduce staff, to rearrange, restructure, and all that due to the exigencies of the time. So if because of COVID, the employer decides that I'm sending 90% of my workers home, no problem. Perfect decision. Understand? The employer must, however, observe the rights of the workers.
Which is?
For example, then, now the workers have a right to be paid. The agreed remuneration, that is one of the rights of a worker under Section 10, of the Act.
Okay.
The right to be paid the agreed remuneration at the agreed time and in the agreed manner.
In this case, they have compromised.
Yes.
They have agreed that they should be paid 50%.
Yes, they should be paid 50%. The 50% must be paid.
Okay.
Now, the employer says that they don't have the money to pay. It is not an excuse to say you don't have the money to pay.
In the meantime, they are paying some managers 100%.
We will come to that. It is immaterial that they are paying managers. But managers are also employees. You do not say because you are paying this man, you are not paying me. No, that's not the issue.
Okay.
You must comply with my agreement with you.
Okay.
Now, if they fail to do that, and they have not renegotiated with the union as to what to do under the circumstances that they state there is no money, then the union is entitled to take the matter up by way of a complaint to the National Labour Commission or institute a court action to recover. And you know that when a court has given decision in a matter, I don't have money is not an excuse, especially when you have assets that the party can attach for purposes of settling the
assets that the party can attach, meaning the company's properties may be used, and sold to pay the workers. Okay.
That is in the absence of any agreement with the workers as to how to pay.
All right.
They could also engage the workers to pay the money by installments. You understand? Maybe in the course of those negotiations, that is when the workers can now talk about, but manager A is receiving this, manager B is receiving it. But normally it depends on the information that you make available.
So this is unfair, clearly, is it not?
Yes, it is unfair. But it is not illegal if they have complied with the agreement.
Okay.
The agreement, the decision to send 90% home, fine, management decision. You cannot compel a manager, an employer, to keep employing an employee that he does not need.
You say, because of COVID, 90% of you go home. We are keeping a skeletal staff. We'll pay you 50%.
Yes.
You are unable to pay the 50%. You are saying you don't have money. Come to a meeting. You are refusing to come to the meeting with the union. You are paying 100% to some managers, and you are still not taking care of us. Meanwhile, when you have asked us to go home because our presence is not required, because there's not much work, you have gone in to bring temporary staff.
Now, let me deal with the issue of temporary staff. The employer can always employ the kind of workers they want. There are some other technicalities regarding temporary staff and what their implications are. The employer can always employ. The important thing is this, that there was no agreement that temporary staff should not be employed.
Okay.
If there was such agreement, then the employer will be acting in violation of that agreement. But in the absence of any such agreement, the employer can always employ. The important thing is that you satisfy the terms and conditions upon which your workers went home.
All right.
Your 90% of the workers, which is the 50%. Those are the important. That is the agreement between the workers and the employer.
All right.
It has nothing to do with a third-party agreement between the employer and another person.
Is it not the best thing, and is it not the fairest thing to do, to rather allow some of this staff to stay on to do what you are employing the temporary staff to come
That
do?
is the perfect situation. And in fact, in some collective agreements and conditions of service, you will have provision to the effect that in the event that workers who have been sent home due to retrenchment or redundancy or whatever cause, in the event that the employer would need to re-employ people, they should be the first to be considered.
They should be given the first option.
First option. To be employed before any other person. So it depends on the kind of agreements that you have. Now, we talk of temporary staff. There is there is something we must be careful about temporary staff. You see, if you look at the Labour Act, Section 75, talks about temporary staff. Temporary staff, you cannot employ a temporary staff for more than 6 months.
Right.
When you do so, after the 6 months, the temporary staff, according to the law, becomes a permanent staff.
And therefore, the temporary worker is entitled to the conditions
the same
that
condition of service
must enjoy
appertaining to
the
permanent staff.
Right.
That is key. The courts have ruled on this. The idea is that it will not be permissible to allow employers to take undue advantage.
Right. Because they could abuse this principle.
Exactly.
By employing people for 6 months, they let them go employ another group for 6 months, and they don't get to benefit from what permanent staff are to benefit.
That is the point.
Right.
Now, the Court of Appeal, in a matter, just for purposes of public education.
It's important.
In the case of Jonathan Agbo Eje versus GCB, this is reported in the monthly, Ghana Monthly reports. Now, this is what the court had to say about temporary staff.
Okay.
It says that it is the considered opinion of the court that Section 75(1), that is the provision relating to temporary staff, of the Act, seeks to protect young graduates like the appellants or young persons from being made temporary employees on a permanent basis, as the respondents did by engaging the appellants for a considerable long time of over 5 years as temporary employees and paying them relatively low salaries.
Right.
The Labour Act, to the mind of this court, is a tripartite document that is a legislation brought about through lengthy discussions and negotiations by the three major parties, i.e., the employers, organized labor and government, and the rationale is to check incidences of exploitation of labor by powerful organizations and employers who were dealing with helpless and hapless young employees, like the appellants in this case.
Right.
It is to be noted that the Labour Act 2003 was passed by Parliament in October 2003 and came into effect in 31st March 2004. It should also be noted that the three major objectives of the Act are to determine the legal relationship that should exist at the workplace between the employers and the workers. 2, to make labor relations predictable. And 3, to ensure that there is a harmonious workplace relation to enhance productivity, profitability, and job creation.
Right. So that is really very clear. And if you're an employer who is in the habit of giving your employees contract which terminates every 6 months, you know you are doing the wrong thing.
Certainly.
Because you want to pay them lesser amounts. You don't want to have any responsibilities towards them by way of their medicals and all those things. Meanwhile, they are supposed to enjoy that. So some actually have such contracts. They say 6 months. So after 6 months, they will renew it again. Then you continue as a temporary staff. Once it is 6 months and you are renewing it for the next period again, it ought to be seen as a permanent
that is the
staff.
point. And the Supreme Court rehashed this in Benjamin Ayer case.
Okay.
And in that case, the court was even talking about casual workers.
Okay.
But not temporary workers.
Exactly.
Which is even a higher level.
Yes.
So the court had this to say at, I think, page 8 of the decision. It says that even though the section does not provide for the automatic conversion of such a worker with a permanent worker after his services have been utilized continuously for more than 6 months as opined by this lordship, it is our considered view that when a worker initially employed as a casual worker and his services is used continuously for a period exceeding 6 months, such a worker is legally under the Labour Act a permanent worker and thus entitled to all the incidences and protections provided for a permanent worker under the Act. This is the golden voice of the Supreme Court.
Okay, right. We'll go to our next issue. So this is very clear. The employer must be willing to sit down with the union of this hospitality company, and the employer has a duty and obligation to keep to the rights of the employees by paying them the agreed 50%. In fact, they were to receive their full salary as agreed upon. But now, because you have negotiated and reduced it to 50%, you have no right to begin to trample upon them. They could go to the Labour Commission and you may be compelled to do certain things, or your properties could be sold to pay them off. Now, the next issue...
Just before I go to the next one, the last part of that issue talked about the failure of the employer to negotiate.
Right.
That is in clear violation of Section 153 of the Act, which says shortly that the parties to an industrial dispute are under an obligation to negotiate in good faith with a view to reaching a settlement of the dispute in accordance with the dispute settlement procedures established in the collective agreement or contract of employment.
All right, thank you. Our next issue, let me quickly get that to you. Okay, so this is from Issa. He's an employee in a Tema-based foreign company and was promoted to senior supervisor, which is a managerial position, after the occupant of that office was affected by retrenchment. A promised formal confirmation has still not happened, despite the fact that he renders the job of that is required, and the benefits associated with that office are not accorded him yet. And he says he does all this with a dedicated sense of duty. He has often used his personal data for office work. He wants to know what the NLC might do if he filed a complaint. So he's been promoted because somebody has been affected by retrenchment. The promotion is oral. They say they'll confirm it. The confirmation hasn't come, but he's in that office doing that job. That job is a managerial position. Is he not entitled to the formal confirmation? And in the absence of the formal confirmation, is he not entitled to the conditions and the salary of the person that he has taken over from?
Fine, something. There are two things. The first is that what has happened to Issa must be a clear case of promotion.
Right.
Not a situation where he has been asked to act.
Okay.
So if it's a clear case of promotion, as is being presented, now, under the Act, the employer has a duty to provide the details of the terms of employment. If you read Section 12, the terms 12 and 13, the terms of employment to the employee. And he must do so within 2 months of providing the employment. And the employee has a duty or a right, he has a right in this case, to receive a contract of employment. So clearly, management is acting in violation of this provision. And so, a complaint to the National Labour Commission, as is contemplating, could compel management to provide the details, particulars, specifications of his contract of employment
and the conditions,
under which he is being employed.
Okay.
Apart from
if
that,
he has served in that office for a couple of years,
yes,
will a determination be made so that he will receive, compensation from when he?
Certainly, he will be paid arrears of salary. He will be paid arrears of salary. I was just coming to the other principle. Apart from this provision in the Act, you and I know that the larger law on contract, based on which some of these principles of labor law are formulated, have what we call contract by conduct.
Yes.
So if by conduct, you have by conduct asked me to work here, you have been promoted, I believe in that, accept, and I'm working. You treat me as such, just that you have not formalized the appointment. nothing prevents you from taking or receiving what you ought to benefit by acting in that, working in that position.
Even though the contract must be in writing, formal.
Yes.
What, the former Executive Secretary of the National Labour Commission, Charles Bawaduah, is telling us here is that if that has not happened, but you were asked to do it orally, that can also constitute a contract. And also by conduct, because you're already doing the job that you have been asked to do. The perks associated with that, office, you should be entitled. So, Issa, you asked if you could go to the Labour Commission. Yes, you could go, and it does look that in the absence of any other, information to the contrary, you certainly will receive your due recompense. A labor is worthy of his wages. We have a couple of people. A couple of people joining us on Zoom, but we have just one more issue. It's very straightforward, and we would like to have Charles Bawaduah give us the resolution of that issue. It's very simple and straightforward. This is from Tina. Tina is in Kumasi. She said she has worked for a Kumasi-based company for 6 years without a formal employment letter or contract. She wants to resign and wants to know if she can do so in the same way as she was employed, that is verbally. And are there any implications for doing that?
Fine. Let this problem is also associated with
the first one. Second issue.
They are quite related.
Right.
Now, Section 9F of the Labour Act provides that the employer has a duty to furnish the worker with a copy of the worker's contract of employment.
Right.
Mind you, when we talk of contract of employment, we also talk about appointment letters. They form part of contracts of employment. Yeah. So that's what Section 9F says. Now, if you read Section 13 also, subject to terms and conditions of a contract of employment between an employer and a worker, the employer shall within 2 months after the commencement of the employment furnish the worker with the written statement of the particulars of the main terms of the contract of employment in the form set out in Schedule 1 to this Act, signed by the worker.
Signed by the employer and the worker.
And the worker. The two must come together and sign. So the duty, the burden is on the employer.
So the employer for 6 years has been violating the right of this employee.
That is completely wrong.
But the employee has not complained.
That is completely, he ought to have complained. But you see, it's in the contract of employment that you know the details of your rights.
Right.
So that it's easier to refer. Now,
her question is, can she resign
She can resign, and I would advise that she should resign by writing for purposes of the record.
Okay. And in writing, she should state that this is what has happened.
Exactly.
Okay.
She should write to resign. She should not resign verbally.
Thank you so very much.
If she resigns verbally, she may be treated as having vacated post.
Okay. All right. So thank you so very much. We have visitor Moses on Zoom. Yes. Hello, Moses. Moses, unmute your mic and let's hear you. Okay, so Moses, we understand that your internet connection is not the best. Who else? Okay, all right, okay, all right. So, like you said, it's very important that even though she was employed verbally and she has worked for 6 years, if she's going, she should do it in writing. And you said if she doesn't do it in writing, she may be deemed as having vacated post. What are the implications of that?
Oh, if you have vacated post, it means that the employer can terminate your employment. Even though he did not write to you appointed, he can write to you terminating.
Okay. And that's not good for your future job.
And that is not good for your future employment, job-seeking endeavors.
Okay.
And so you should formally write to resign.
Great.
And move on.
All right. Okay, Osman. Hello, Osman.
Yes, sir.
Yes, let's hear you.
Good afternoon, sir.
Good afternoon.
Yes, please. The question that I want to ask is: earlier your host make read a provision from Supreme Court that says that if you work for 6 months for a company, you are entitled to all the benefit that a permanent worker would. So in this case, are you supposed, if you work for a company for 6 months and more, are you entitled to be made permanent, or you can still, the employer still have the right to put you on contract?
All right, thank you. We'll restate that. He stated it, I reaffirmed it, but we'll restate that for you. Yes, so you heard him.
Yes, I heard him. You see, what he's seeking to know is whether you must now deem yourself permanent, or is the employers who do that. But you see, the point is that if you don't take on the employer on that, for him is,
yeah, you continue to,
he will continue to treat you as, but you must take him on. Take the employer on. Under the law, I am entitled now, having worked for 6 months continuously, to be a permanent worker and to be treated as such. I'm requesting that to be so done.
All right. And you remember that we started with unfair labor practices and emphasized the need for unions. You need to have organizations. Sometimes if you are going to do these things alone as an individual, it may not be good for you.
They will intimidate you, they will victimize you, right, and all that.
All right.
But if you belong to the union, right, the trade union will take the matter up
for you.
And mind you, when the trade union takes the matter up, it is normally not the local union leaders who are fighting, but the national union, who have no relation with the employer whatsoever, except that they are representing their members. Okay. So they are in a position to fight and do so effectively.
Thank you. Who is next on the... Hello, Justice?
Hello?
Yes, go ahead.
Hello?
Justice, go ahead. We are listening.
Yeah. Good afternoon.
Justice, go ahead. We are listening.
Yeah. I was working with one of the hospitality industry during the COVID-19. They gave us determination of appointment without giving us any benefit. And first of all, we have contributed in Tier 3, which is, it came to a time that they said the employer has stopped contributing as the money back. In addition with us, then the employer, it came to a time that the money that we have contributed should be, they will divide it into 2 and give us half. So my question is, Tier 3 that we contributed, we the workers contributed, is it right for the employer to take half and give us half? And even the determination of the appointment without giving us any benefit, is it right?
Thank you, Justice. You can mute now and then listen to Charles Bawaduah. Yeah.
Fine. If the reason for the termination was COVID, as he is saying, it is not right the manner they were terminated. They ought to have been engaged. They ought to have sat down to negotiate a way out. To the extent that that was not done, it cannot be right. Okay. Now, as regards Tier 3 contributions and other monies which might have accrued, at the point of termination, these are benefits which are accrued and for which the worker is entitled to receive, even before the date of termination. Now, if you read Section 18, now it makes this point very clear. It says that when a contract of employment is terminated in a manner stated in Section 15, those are the grounds of termination, the employer shall pay to the worker, 1, any remuneration earned by the worker before the termination.
Right.
2, any deferred pay due to the worker before the termination. 3, any compensation due to the worker in respect of sickness or accident whatsoever. Now you come to 2, the employer shall pay to the worker not later than the date of expiration of the notice or remuneration due to the worker as at the date. Okay. So if Tier 2 contributions were made, other benefits had accrued. That is something that has already accrued to the worker for which you cannot take away when you are terminated.
Right.
And more importantly, you must pay this money at the date
of expiration
of the notice that you have given.
Okay.
If you did not give the notice, the law says that you must pay the day immediately after the termination.
Okay. So, like Charles Bawaduah has repeated over and again, you see, when you have a right and you don't assert it, you may not benefit from it. So assert your right, and that's the point. It is better in a working environment to have a union and to belong to a union and to have the union assert it on your behalf. Hello, Mugis.
Yes, Council, I can...
Go ahead.
Hear you. Please, can you hear me?
Go ahead.
Hello. Okay. Thank you very much, Council, for this opportunity. Please, I want to know, in a case of eminent employee, when you are given an appointment letter, and it is stated clearly in your appointment letter that in 6 months, you will be confirmed and you will be written to alert you whether you are confirmed or not. So after that 6 months, if you are not written to by your employer, do you have the right to compel your employer to write to you? Or it is legally confirmed that you are a permanent employer or employee? Okay. Thank you.
Thank you very much, Mugis. So questions of probation, right?
Yes, probation. This is a very important question because it's happening.
Yeah.
Now, let me say clearly that this is a matter that has come before the National Labour Commission a number of times. The decision of the commission is that if after the probation period, your employer has not written to extend the period, you know, under the agreement, you can extend the period of probation.
Right.
You have not received a notice that it has been extended, and there is no notice saying that you have been terminated because you do not satisfy the employer during the probation period. It is deemed that by necessary implication, you have been confirmed, and you'll be treated as a confirmed employee.
So, Mugis, by operation of law, if your employer says, we will write to you after 6 months to let you know that whether you have been confirmed or not, and they have not written, it is deemed as, and if they have not written to you to say they have extended the probation period and so on, you are deemed as having been confirmed. Therefore, you'll be entitled to all the conditions, the benefits that come with that particular employment that you have been taking on. We'll take our very last contributor or questioner, Moses. Hello, Moses. Let's hear you.
I have a question. Can you pick me last?
Yes, me.
Okay, so Moses, I tried to give you some time so that you could respond, because I discovered you were listening to TV or something rather than listening direct. But it does appear your internet is not helping you that much. Right. So particularly having listened to all the concerns that have been raised by those who joined us, how will you summarize your interaction with us today?
I would say that there are several violations of the Labour Act taking place at various workplaces throughout the country. That is a fact. I also say that the majority of these cases do not come up because they are not challenged. And there is no way you can enforce your right if you don't stand up to it.
Okay.
So I will encourage Ghanaian workers, one, that they should be encouraged to fight their rights, ensure that no violation of their rights as provided for under the Act is left unattended to. Now, apart from that, I also encourage workers to join trade unions. That is key. It is a trade union which is better placed to fight your rights more effectively, because the leadership of the trade union understand the act.
Right.
They practice it. They are better placed to get better conditions of service for you.
They may even actually engage lawyers to assist them.
To assist them.
Right.
They should also
we have
avoid.
We have run out of time, and we want to say we are very, very grateful to Charles Bawaduah, who is a private legal practitioner and former executive secretary of the National Labour Commission. I received messages of some of you asking, is the law in his head or what? It's in his stomach. All right, thank you. Have a good afternoon. This has been Covered and the Law. This is your legal light and health law in these trying times.